Hello everyone, and thank you for joining us for today's presentation as part of the Industry Insight webinar series. The topic this time is Ethics and Social Media. Speaking today will be Claude Decloux from LawPay. Claude is an attorney licensed in Texas, Colorado, and California who speaks regularly on legal ethics, law office management, and trial-related topics. In 2011, he won the highest statewide award from the State Bar of Texas for his lifetime contributions to CLE. He has been invited to speak in more than 100 programs since 2015. He's also served as a course director for numerous institutes and advanced courses. Mr. Decloux has a long legacy of bar service. He has served as the president of the Austin Bar Association and chair for almost every major state bar-related entity, including the Texas Bar Foundation. The Industry Insight webinar series is hosted by the ABA Legal Technology Resource Center. To stay updated on upcoming webinars or view previous videos, visit ambar.org/industryinsight. You can also stay up to date on the latest legal technology news through our blog, www.lawtechnologytoday.org. Presentation today will be followed by a Q&A. Please enter your questions into the question box in the webinar panel on the right side of your screen. All questions will be addressed at the end of the presentation. We're recording this webinar and we will be sending the video in a follow-up email in a few days. We'll also post a video on our blog, which again is www.lawtechnologytoday.org. Thank you all for joining us. We'll now begin the webinar.
Thanks, Austin. This is Claude Decloux, and welcome everybody. Now, I will tell you, I will be going a million miles an hour because this is basically an hour presentation with a lot of explanation that I'm jamming into 30 minutes. And what I will do at the end, though, you will have a very easy slide to get in touch with me. If we don't get to all of your questions, I'm happy to do as much as I can with you offline, so you can send me an email simply at claude@lawpay.com with your question. I'm be glad to answer it and correspond as much as we need to answer whatever questions you have. Also, if I mention a form or if I mention anything that you're interested in, I have just lots and lots of great forms for lawyers to use for various things. Okay, so let's talk though, again, this is going to go fast. The purpose of this presentation is to show you the mistakes that lawyers have made in using social media, you know, especially in this time when people are using social media willy-nilly, including some politicians that we all know. You know, it's important for us to remain very professional in the way we use it. And of course, if you do it wrong, it ends up in malpractice, your breach of your fiduciary duty, and other ethical breaches, and of course, monetary damages. Here's a funny thing right out of the Bizarro comics, where God is he handed Moses the 10 Commandments. He has 5 more. He says, oh, here's 5 more for later about internet ethics. Do we need some new commandments? Moses didn't use Facebook, so I guess we do. All right. And then to quote further from the People's Exhibit A, your Twitter feed, @HoldUpGuy, I'm in the getaway vehicle with the money and hostages. Where are you? Yeah, see, that's the whole point, that this use of social media, which is so normal and so knee-jerk and so gets us in trouble all the time. So here's what we're going to cover in today's session. Hopefully we'll have time. Why you guys, why all of us, men and women, need social media savvy. And then danger area 1, disregarding confidentiality. We do that all the time with social media by accident. Unethical information gathering. Nowadays, you know, it's unethical to gather information some way, but sometimes some courts have even said, if you don't research people online, you may be committing malpractice because you can get valuable information that could help your client in the case. Failure to assert client control, making sure your client isn't using social media. That is the biggest danger that we have now, is our own clients using it improperly. You know, I am the course director for the State Bar of Texas's biggest advanced course for lawyers. It's called the Advanced Trial Strategies course every year in New Orleans. And when I interview these plaintiffs' lawyers, they always say, look, we can't take a case until we check out the social media of our client because it could just doom our case. Danger area number 4, evidence preservation, spoliation. You know, telling people, delete your Facebook page, delete this, delete that, delete all these things. Well, that's spoliation of evidence if it occurs in certain times when the cases are ongoing, or if you received a letter saying to preserve evidence. Danger number 5, the ethical conduct involving jurors, you know, contacting them surreptitiously. And danger area number 6, the impact of what you share. Okay, why you need it. Look at these statistics. This is YouTube. 1.5 billion monthly logged in users. 400 hours of video are uploaded every minute. 400 hours of new video uploaded to YouTube every minute. Facebook, 1.94 billion users. Approximately 1 billion registered users of Twitter. 317 million monthly active users, and some famous ones, as we know. LinkedIn has 500 million registered users, 500 million registered users all over the world. These are numbers, frankly, folks, that we cannot comprehend. And Instagram has 700 million active monthly users. Over 60% log into Instagram every day. That's 420 million people use it every day. Social media by the number, 78% of all adult Americans have at least one social network account, and 58% have two or more. With me, I have to have a Facebook page because I think you have to have that, and between that and LinkedIn, they're my two. I don't have time really to tweet anything. 16 minutes of every hour spent online, listen to this, is spent on Facebook. There are more Facebook profiles, 5, created every second than there are people born. 4.5. So isn't that just incredible? There are 5 created every second and only 4.5 people born. So more than 1 billion tweets are sent, billion, every 48 hours. And every 60 seconds, over 293,000 status updates are posted on Facebook, and 4 million likes generated every minute. So we have a new duty of competence. If you look at the ABA Ethics 2020 Commission, the new Rule 1.1, we as lawyers have to maintain the requisite knowledge and skill abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. So the trend in the courts nationwide is to hold lawyers to a higher standard regarding technology, and you will see there is a duty to Google in some jurisdictions. So let's look at that. Johnson versus McCulloch, 306 Southwest 3rd, 551. That's a Missouri case. Affirmative duty to research jurors online. Folks, I'm a longtime board-certified civil trial lawyer, picked many juries. That sort of boggles my mind that we have an affirmative duty to research jurors online. Of course, if you have the time. Lots of times we're handed the jury register right before we walk in and do the voir dire. Okay, Kennedy versus Adams. This is a Ninth Circuit case. The failure to investigate social media, recantation of sexual abuse victim held to be inadequate assistance of counsel. So this sexual abuse victim recanted online. They didn't find it. Inadequate assistance of counsel. And then Womack versus Yeoman, which is a Virginia case in Westlaw, the dangers of not being conversant in technology are discussed there. Danger area number 1, disregarding confidentiality. Look before you tweet. This tweets by Sarah Peterson HERR, a research attorney in Kansas court, where she tweeted to this other person during trial, "You naughty, naughty boy." And why is Phil Klein, who was a DA, smiling? There's nothing to smile about, you know what bag, you D-bag. And so she got caught, gave a public statement. I don't think that in addition to communicating with a few of my friends on Twitter, I was also communicating with the public, which was not appropriate for someone who works in the court system. So I apologize that the comments were made on Twitter and thus public, and they were perceived as a reflection on the Kansas courts. And she was fired and given an informal admonishment. Gee, I can think of many people who need to apologize for some tweets. Comments on your own client in the matter of Peshek. Here is an attorney, a criminal defense attorney, who takes his client and he says, "My client's taken the rap for his drug dealing dirtbag of an older brother," and he says, "Well, he's no snitch." So he's revealing client confidences. And then he goes on, "My client is in college." Just goes to show you that a higher education does not imply that you have any sense. He's standing there in court stoned right in front of the judge, probation officer, prosecutor, and swearing he was clean. These are the kind of things. Why do people tweet that? What made them think that was a good thing to do? Maybe they just needed to get those tweets out of their system. Confidentiality is short. Remember, our model rule 1.6, which is 106 in Texas, it's 1.6 in Missouri, in many other states. A lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent and the disclosure is impliedly authorized in order to carry out the presentation or disclosure is permitted by paragraph B. So that was the rule that lawyer that we saw in the previous slide violated, and he was suspended from practice for 60 days and fired after 19 years with the public defender's office, all because of these silly tweets. Danger area number 2, unethical information gathering. Don't misrepresent who you are or act with deception. That's the rule. Think about that one sentence. don't misrepresent who you are or act with deception. The ethics opinions about contacting witnesses, I think you can download this slide deck if you can. These are, obviously, I don't think you can move fast enough to copy down these opinions. Of the Philadelphia Bar in 2009, New York City Bar, September 2010, New York City Bar again, September. There's a State Bar Association. It was the City Bar and the State Bar, and the New Hampshire Bar Association, 2012. And remember, you can't friend a witness on Facebook under false pretenses. A lawyer shall not knowingly make a false statement of material fact or law to a third person. A lawyer shall not engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Here are some cases of false friending. In May 2012, Ohio civil suit filed against the insurance defense firm, the carrier, and the investigator, or the investigators alleged online impersonation to gain access to the private Facebook page of a minor plaintiff in a dog bite case. Claims of invasion of privacy and violation of wiretapping, of the wiretapping statute alleged because they misrepresent who they were. June 2013, Cleveland assistant prosecutor filed for posing on Facebook as the fictional baby mama of a murder defendant in order to persuade two female alibi witnesses not to testify. So she was trying to get them not to testify by posing as somebody else, and she was an assistant prosecutor. In other words, she wanted this guy fried, and she was trying to talk these alibi witnesses out of testifying by using a false persona. Don't communicate with a represented party. This is hard for some people because we're all so connected. Rule 4.2, model rules. A lawyer shall not communicate with or cause another person to communicate with an individual represented by counsel without the prior consent of that individual's attorney. Now, this I want to point out, if you're looking at this May 2011 San Diego Bar Association legal ethics opinion, is a really good, in-depth, well thought out. It belongs in a hall of fame of some legal ethics opinions. I really liked it. So if you want to make a note of that one, Google it online, San Diego County Bar Association Legal Ethics Opinion in May 2011. You can't request a former co-employees of the plaintiff in a labor case. They are considered represented parties. The crux of that is a long explanation of, look, when you're in a case and you think there's, and representing an employee and there's some employees that are still with the company, you can't, reach out to them individually. Ethically, they're supposedly still employees of that company, and you have to let the company's attorney know that you want them. They're considered to be represented parties. And here's this pending ethics case of John Rapatelli and Gabriella Adamo in New Jersey. They allegedly directed their paralegal to friend a young male plaintiff in a personal injury case, even though he was represented by counsel, to gain access to privacy-restricted portion of his Facebook file. Danger area number 3, failing to assert client control. This whole section is the dangers of not knowing what your client is doing on his or her social media. Gulliver Schools versus Snee. The daughter won 80 grand, and then she posts online, Mama and Papa Snee won the case against Gulliver, which is Gulliver Schools. Gulliver is now officially paying for my vacation to Europe. Suck it. Well, guess what? They had a confidentiality provision in the settlement, and it was torpedoed by her Facebook post telling Gulliver to suck it. So it's just incredible the damage that you can do to that. Here, West Virginia criminal defense lawyer ordered to show cause why she shouldn't be held in contempt for allegedly giving her client a copy of the packet containing the identity of a confidential informant. The client's roommate then posted photos of the packet, including the name and address of the confidential informant, and bragging about exposing the rat. So there was an imposition of a monetary fine. I think in some states he probably would have gotten an award. The dangers of not knowing what your client is doing. This is a famous little controversy involving the rapper 50 Cent, or 50 Cent, or however you want to. He was ordered by the bankruptcy judge to explain during his bankruptcy why he's posting photos of him in piles and piles of money. See that thing on the left? It says, I'm broke, in piles of $100 bills, in bed surrounded by piles, and behind him, piles of $100 bills behind him. And so, guess who saw that? The bankruptcy judge. Come here, Fitty. Let's find out what's going on with you. All right, be aware of what the prosecutor is posting about the case as well. The prosecutor posted on Facebook in People versus Armstrong a plot to kidnap the key prosecution witness. That was not good. In Missouri versus Polk, the DA's tweets before, during, and after trial called troubling and concerning by the appellate court. So I don't understand why lawyers post during trials. Just remember these words. Don't post during trials, period. Don't talk about your case. Now what we see is we're having problems with judges posting during the case. Wow, I'm handling a big case. I'm such a cool judge. Let me show what I'm doing. And they will comment on the case. Well, that's clearly inappropriate for the judge to be commenting on a case during trial publicly. All right, danger area number 4, evidence preservation and spoliation. Of course, spoliation means you're doing something, you're getting rid of it. It should be spoliation or spoilation, but it's not. It's spoliation, but it means the same thing. Our Rule 3.1, a lawyer cannot unlawfully alter or destroy evidence and cannot direct or assist others in the unlawful destruction of evidence. This is Allied Concrete versus Lester, 736 Southeast 2nd and 699. That's a Virginia case, 2013. Wrongful death case, the surviving husband was told to go clean up his Facebook page, and he then answered sworn interrogatories that he didn't have a Facebook account. Well, look at that, $722,000 in sanctions. And the plaintiff's counsel resigned from the practice of law, and in June 2013 had his license suspended for 5 years by the Virginia bar. Okay, so that was a very bad decision to tell your client to clean up a Facebook page. Now, we're going to go into that a little more in detail, because you can tell your client to remove, but you can't tell them to destroy certain things. You can tell your client to change the look of the page, but you cannot destroy anything. And if they ask for it, you have to give it to them. So spoliation is the intentional, reckless, negligent holding, hiding, altering, fabricating, or destroying of evidence relevant to the legal proceeding. Now, what is the purpose of that? I'm going to stop right there, because in one case I had as a plaintiff, there was a speed tape. I was suing the railroad for an intersectional collision where the railroad was allegedly speeding, and these locomotives have these speed tapes on them, so they'll show you how fast they were going. Well, they had asserted all the way through the case that there was no speed tape on this locomotive and it wasn't going fast. Well, I got the brakeman on the stand in front of the jury, and he didn't know about that previous plan to say there wasn't, and he testified that he saw one on there, and sure, it was working. I got the judge to give me a spoliation instruction to the jury saying, and the spoliation instruction says words basically to this effect: ladies and gentlemen of the jury, if you find that there is a specific piece of evidence that is in existence and specifically in the control of one party, and they don't produce that piece of evidence, you may assume that piece of evidence does not assist in their case. And that's exactly what the jury did. He gave that instruction. The jury found there was a tape. It was against them, and I won that case based upon that spoliation. So spoliation is a very powerful instruction to the jury. Gatto versus United Airlines. Personal injury plaintiff deactivated his Facebook account during the middle of the discovery, unbeknownst to his lawyer, held to be spoliation. What's the moral again? Know what your client's up to. Patel versus Havana Bar Restaurant. This is Eastern District of Pennsylvania case. Plaintiff in a premises liability case solicits witnesses to change their stories via Facebook, then deletes the Facebook message. This does remind me of another case I had where the opposing party was threatening my client, and he was so stupid that he put on, as the answering machine's going off, says, and no one's ever going to know about this call. Beep. That didn't help his case at all. So again, what's the dangers of spoliation is tell your client you can't change these things, or you can't destroy any evidence. You can change your page, can't destroy it. Can you advise, there is my next slide, can you advise your client to clean up the Facebook page? Yeah, New York County lawyer ethics opinions. See, all of these ethics opinions, they basically will come down. Some of them are different, but I think the modern theory is, yes, you can, but they can't destroy anything they take off the page or claim it wasn't there. All ethics opinions looking at this issue says it's ethically permissible to provide advice to clients on what privacy settings to implement, as well to counsel them on the content they post I'll say it's ethically permissible to advise clients to remove or take down social media as long as no spoliation of the evidence occurs and all the evidence preservation obligations are adhered to. Danger area number 5, ethical conduct involving jurors. Using social media to research jurors. Ethics opinions say it's okay to research prospective jurors using social media. Those are those ethics opinions, and if you get a copy of the slide deck, you'll be able to do them. I just can't read them fast enough. Both stress that using caution as not inadvertently communicate with the juror. Sites like LinkedIn and Twitter inform users who've looked at their profile or who's following them. This can constitute an impermissible communication. In October 2013, the Hustle mortgage fraud trial. This is one that they made a movie out of with Jennifer Lawrence and Bradley. Against Bank of America, jurors complained about first-year associate on the defense team peeking at his LinkedIn his file. Subsequent rulings on what constitutes communication. ABA formal opinion 466 in April 2014. It's okay to review a juror's internet presence as long as no contact is initiated. The fact that a juror or potential juror may become aware that a lawyer is reviewing his internet presence when a network setting notifies the juror of that doesn't constitute a communication from the lawyer. I mean, in other words, pretty much what we're getting at, if you put it out there, folks, the folks have a right, and you let anybody see it, you can't complain when they go and look at stuff that you have made available to be viewed. And so those are subsequent opinions in Pennsylvania, West Virginia, Colorado. You can't use what you learn on social media to discriminate. This is a case right here in Austin, Texas. Our assistant DA, Steve Brand, Facebooks the jury during voir dire for robbery, trial of Darius Lovings. He strikes an African-American woman from the panel because of her NAACP references on her Facebook page. So Batson challenge is made and Brand loses. He was then fired by the DA for racially insensitive remarks. Danger area number 6. You should take the plea. This is what 2 prosecutors, the Pittsburgh area District Attorney Julie Jones poses for a photo toting a shotgun along with a police officer holding an assault rifle. And the photo is posted on Facebook with the caption, "You should take the plea." The DA was not amused and saying Jones's conduct is contrary to office protocol. Now, why would a DA do that again, you wonder? Maybe it's just because I'm old because I have a 6 in front of my name, but it's so obvious that you don't do that. Risk of advocating for a client on social media. Roxanne Conlon's pre-trial Facebook post questions whether her client can get justice in a trial being postponed due to her concerns over tainting the jury pool. And then defense attorney Mark Griffith, he has prayers on his Facebook page, prayers for his client, and met with gag orders from the Ellis County judges. All right. Courtroom victory selfies. Wisconsin lawyer, this is September, 2 years ago, Anthony Cotton snaps a victory selfie with acquitted murderer, then posted on Facebook. The judge didn't like it and ordered Cotton to return to the court to explain himself. Zealous advocacy, oh my gosh, I can't even, since this is a family show, I can't actually tell you what this guy said. But if you want to look up, Google the matter of James Hansen and get a more clear description of what this guy, James Hansen, said, you can sort of tell by what he said. Indiana attorney sends a client accepted a profanity-laced Facebook post, which he says, I'm going to gather all the evidence and I'm going to you so hard that your teeth come loose. I've got you in my sights now. He was charged with felony intimidation and 30-day suspension from the practice of law. But it's a very interesting decision to read. Sealed information policy critiques. Louisiana lawyer Joyce McCool uses Twitter and other social media to publish misleading and inflammatory statements about the judges to promote an online petition about child custody cases that contain sealed information. She's disbarred for that. December 2014, an Air Force lawyer posts comments on Facebook critical of the military's policy on sexual assault, resulting in a criminal investigation of that lawyer. So here are the practice caveats. Refrain from posting during trials. Refrain from any commentary about your clients, period. You always have to remain the adult. You have fiduciary duty to this client. And the essence of the profession is our confidentiality and discretion. And remember, if you've listened to any of those, wonderful NPR things about people who send posts, you might send out 335 wonderful, articulate, intelligent posts, but that 336 might come after you've had a little too much Cabernet Sauvignon on and it comes out racist or homophobic or something like that. That's the post that you will be known for the rest of your career. Remember that story of the woman who posted, she was on her way, a business trip to South Africa, and says, "Ooh, I'm on my way to South Africa. Wow, first trip to Africa. Hope I don't get AIDS. Ha ha, just kidding, I'm white." By the time she landed, she had over 1 million responses. And believe people we live in a shaming culture. And when you do something like that, you're asking to be shamed. And the shamers are far more horrible than your post. She ended up losing her job. She literally had to go underground because of the millions of people who saw that. And it was intended by her to be a joke. Ha ha, don't worry, I'm white. But now let me talk for a second, and I may give a little more time to this if you have any questions about it. There is some misunderstanding. I know the young attorneys say, "Hey, when I finish a good job for a client, I just want the client to post, will you post on my website, on my law firm website, what a great lawyer I was." Now, let me please try to understand this. You're not supposed to do that because a lot of clients don't even want people to know they needed to go to a lawyer. So if you're asking the client to breach your own fiduciary duty. Now, many clients will want to do it anyway, but I'm just saying you can't ask for it. And if they say, may I leave a message, say, look, I just want you to understand, I can't ask you to do that because I owe you a complete duty of confidentiality, and that even extends to the fact that I represented you in anything. I'm delighted if you want to do that, but I can't ask you, and you don't have to do that because it will breach the confidentiality that I owe you if you want to do that. Anyway, and never tweet or post anything you wouldn't say to a person's face. That goes for just about anything you say anywhere. Review your client's social media activity to see if at all possible, before signing on. And remember, tell your client that every single post is permanent. You'll be judged by your worst social media posts, not your bests. I have to admit, I think the American public is getting a real kick out of seeing these tweets that are coming out of our politicians. And it's almost like a daily, can you believe this? Lawyers would probably, for some of those things, be in big, big trouble and subject to discipline, but I guess that's the country we're in nowadays. Legal representation entails a willingness on your part to refrain from posting in most cases. Never reveal anything, your strategies, your evidence, your attitudes, your bills, your opinions during litigation. These are what you tell your client, and of course you live by those too. Never tweet or post anything you wouldn't say to the person's face. And spoliation, don't try to destroy or permanently delete evidence. These are your advice, the 6 things that you tell your client at all times during this. So here's your takeaways. Consider you rarely need to use social media. You shouldn't do it in trial. You're a trusted confidant. You have ethical duties to your client. If you do use it, always tell the truth. If the truth will get you in trouble, you're probably not using it right. If the truth is going to get in trouble, you're probably using it inappropriately or unethically. So before using social media, consider every positive, negative connotation that could be attached. And do not ask clients to post something for or about you without informing them. As I said, they don't have to do that. You can't ask them to because you owe them confidentiality. Now, the last thing I will say, we have a duty to improve and defend our profession. We are the guardians of the rule of law. That's our social compact to handle disputes through rules and processes rather than brute force. So make sure people understand that important. Always support the fair administration of judges. Make sure people understand that the judiciary is the 3rd branch of government, and always speak out as a true professional when you see undue criticism.